This is Earl White, real estate attorney. This is a video about how to correct an error in a deed in New Jersey. Our firm has helped many owners correct errors in their deeds, whether it's misspelled names, incorrect lot and block numbers, wrong marital statuses, because each of these type of errors can have serious legal consequences if they are not corrected in a timely fashion. First, let's discuss the types of errors that commonly appear in real estate deeds and why you as a real estate owner would want to have that document corrected. First type of error we'll call incorrectly spelled names. Now it's just a typo, just an error, so it doesn't sound like a big deal because everyone knows who the true owner is, but the problem becomes when you go to sell or refinance the property. There's going to be a title search on the property, and they're going to run name searches on anyone who is named on the deed. And if it's an incorrect name on the deed, they will run a search on that. Another common error that we have in deeds is if there's an incorrect marital status set in the deed. That can be, for example, if you're single, it says married. If you're married, it says single. Or if there's some other arrangement such as tenants in common, joint tenants with right of survivorship that you may have wanted differently. So those statuses, if they're an error, it can cause serious problems. For example, if we're talking about a deed that states married, but the people were single, that's a problem because if individuals are single, they would want, or they may want, the property to pass down to their next of kin as opposed to the person on title. And so if it gets incorrectly listed as husband and wife, that implies a different legal meaning that if one of you were to pass away, the interest would automatically go to the other. That's how it's called tenants by entirety, and that's what applies to husband and wife. So if you have a deed that says single incorrectly, then you can update it just to avoid any confusion that if one person passes away, that it would then go to the other. Therefore, there's no questions if one person passes away that the property was intended to go to the other person, which is not signified if the word single is there. Another type of error in a deed is an incorrect lot and block number. And which in New Jersey are the designations of a specific property. Addresses are loose and informal. Lot and block number is what is needed. If there is an incorrect lot or block number, it is possible that a deed could either not get recorded in the correct place. So if there's an incorrect lot or block number, then it's important to get that fixed. There have been lawsuits in cases where deeds were literally not recorded or recorded on the wrong property because lot and block numbers were wrong. So don't take any chances with this. If you have a lot and block number, to avoid any confusion about where the deed is recorded, what property it's recorded, or who the owner is in that public record. If it's not recorded, it still show the old owner. Get those lot and block numbers corrected. Now let's discuss what goes into a deed that is fixing an error in a real estate deed in New Jersey. These type of deeds are called corrective deeds, meaning they correct an error as opposed to conveying, so no ownership is being conveyed. It's a corrective deed. So what are the contents here? You still have to list the grantor, the current owner, the grantor, and you'll still list the grantee, which is the same person. Then in the deed, you'll have a recital. The recital in the deed is going to reference the old deed by date that it was recorded, date that it was signed, and prior owners. So you'll reference the prior deed. Then you'll have a recital. That deed had an error, and it will explain the nature of that error. And the next part of it will say what the correction is. So you want to have the parties' names, you want to have the prior error, and then the explanation of the change from that prior error. So all of that, obviously if it's a deed, then it also should be notarized by a public notary or an attorney and needs to have a proper legal description with the right lot and block numbers for it to be in recordable form, for it to make it to the county in the right location and the right recording, so it is public notice to the world of the correction. Now let's discuss the specific steps that you should follow to correct the error in the deed. First step is to select an attorney to assist in the deed or make the decision to conduct the corrected deed on your own, which is legally permissible in New Jersey. Obviously, I'm an attorney, so I'd recommend using an attorney, but regardless I think it's important to use an attorney for several reasons. First of all, as mentioned prior in this video, they need to be specified. There needs to be specific detail about the error. There needs to be specific dates, lots and block numbers, prior book and page numbers for the deed, and there's also specific supplementary forms. So for example, there's a GIT REP 4, which I won't go into in the detailed video, but every recorded deed needs to have some kind of GIT REP form in New Jersey. GIT REP 3 is normally used, but you need a special GIT REP 4 form when you're doing corrective deeds. You want to have an attorney to help you prepare the language to make sure all the names match up, make sure the correction language gets in there, and this will also save you a lot of time. Sometimes the largest amount of time when you are submitting a deed for recording is that the county is always going to review the conveyance documents, and they're going to come back with specific requests or modifications that, depending on which county and which person at the county is evaluating it, then the attorney can deal with that representative to make any requested changes in the conveyance documents. This can save a lot of time, and in some cases we may just make the change as the law firm requested by the county. Other times the county may be unreasonable, and then the attorney can take up the issue with the supervisor or explain the position why this deed is in recordable form. So step one, either you're going to DIY it or you're going to hire a real estate attorney to help you with the. Step two is you have to prepare the documents for recording. So those documents, the 3 documents you'll need for recording this deed, are the corrective deed itself. And we've already talked about earlier in this video that you should have recitals and explanations of the error, the correction, and cite all the lots and blocks and dates relating to these changes. So you need the deed. You also need a GIT REP 4 form, which basically is a document that you produce in order to avoid paying any realty transfer tax or any other cost related to the transfer that would apply if it was a conveyance of ownership interest. This obviously is not a conveyance of ownership interest, and therefore you would have a GIT REP form or a specifically drafted GIT REP 3 form to ensure there's no realty transfer tax or other issues with the recording. You need that form, and then you also need an RTF1 and an affidavit of consideration form. This affidavit of consideration is a formal, notarized, signed statement by the owner explaining that there's no consideration because it's not conveying ownership, so you have to specify no consideration. And then there's a section in the affidavit of consideration where you have to provide a succinct explanation, usually no more than 3 or 4 sentences, that explains the reasoning for the deed. So you would again recite here what the nature of the correction is, and then you need to have that form notarized. So those are the 3 main forms you need to produce: the deed, the GIT REP form, either 3 or 4, depending on the county may request one or the other, and then the affidavit of consideration. Okay, so now you've picked an attorney, you've decided to DIY it, you have produced all the documents that you need for recording. Now you have to have them notarized. In New Jersey, notarization rules, in New Jersey, the affidavit of consideration needs to be notarized. The GIT REP form, whether 3 or 4, that can just be signed. It does not need to be notarized. Okay, so now you've properly created the documents, the corrective deed and supplementary forms. You've properly signed them. Now you need to submit them to the county for purposes of recording. They can be effective upon delivery, but the truth is that you need to get it recorded because New Jersey is a race notice state. That means that the latest document recorded takes precedence over prior documents. So you want to get these things recorded as fast as reasonably possible. You can do e-recording of the documents, so you scan in the documents and submit them via an e-recording portal, so they'll get right to the county. That is my personal preferred method of recording documents when it can be done, because A, there's no chance of losing the documents, like sending it in the mail to the county to have them processed. It could get lost. And I've seen that many times where you mail the document to the county, either gets lost in the mail, the county processing it loses it, or the county then mails it back, and they only use regular mail. They will only use regular mail, and then it gets lost in the mail. E-recording, then you will not have to worry about documents being lost because they'll stay with you or with the attorney and while the recording's going place. There's only a small cost for e-recording, typically less than $100 to use an e-recording service, which is somewhat comparable if you're going to use an overnight mail to the county of the. So that's the other method, right? So you have e-recording, you can mail the conveyance documents to the county. that is also going to have a cost. If you're going to do overnight mail, you're looking at somewhere around $50. And so if you're going to pay $50 for the overnight mail to the county, you might as well just pay for the e-recording, even if it's even if it's $50 more. So you can overnight mail to the county. That is also allowable. The county will then process the paperwork, and they can respond back via phone call for any edits or revisions, or they may mail back the document via regular mail with noted corrections they need done, which is a giant waste of time and again a risk that would get lost. As opposed to e-recording, just submit them and you can get live feedback from the county as to whatever edits that they're requesting, so it can be done much faster to expedite the process instead of waiting for snail mail. You can also go drop off the documentation in real life, so go down to the county registrar, hand the documents in, and then you may be able to get some feedback from them in real time as to any errors. Oftentimes, if you bring the documents there yourself, so then the county tells you that you have to go get an attorney, even though it's not legally required, they will still say, okay, look, you have to go get an attorney, because they're just tired of dealing with incorrectly drafted documents and wasting their time. Get those documents recorded. As long as you notarize them and created them in the way I previously discussed, you'll submit them to the county. The county will almost always have some feedback to the documents, some tweaks, and then you deal with the county, either the attorney or you will deal with the county in making the modifications, and that will be sufficient to get them recorded. So the whole process we're talking about, from the beginning of deciding to create the documents to the end of getting to the recording, as long as everyone acts with relative swiftness in each of their specific roles, you can complete the whole process in 30 days, sometimes even shorter than that, depending on the backlog of the county in recording the documents. Thank you for watching this video about corrective deeds in New Jersey, how to do it, the types of errors that need to be created, and the risks with them. Feel free to reach out to our law firm if you need assistance with correcting a deed in New Jersey.